Hello and welcome back to my channel. My name is Funmi Owolabi and today we're going to be doing What's the Tea in Privacy with tea. So I thought I would put a really fun spin on British people's favorite drink, and we're going to be looking at penalties that have been issued in the United States for this year. So my plan with What's the Tea in Privacy series is we're going to look at piping hot tea, meaning tea that is like currently active. We're going to look at tea that's goldie but an oldie, right? We're going to look at tea that's still relevant to today. And then we're also going to look at tea that's like, it's old, but we're still curious, okay? So I found this website online. It's called privacylawmap.com and it talks about penalties. So the tea that we're going to be looking at on my channel are fines that have been issued. And the reason I decided to start What's the Tea in Privacy series is because I think it's really important to see the different elements that regulators have looked into based on how they have issued fines to different organizations. So I've done lots of reviews on my channel on, different notices, my own notice. We've done some videos on privacy in practice, but now we're going to be looking at what's the tea in privacy. And we're going to be looking at tea in every geography. But for now, I wanted to talk about something that happened in the United States. I find this particular website really valuable because it looks at the violation type. Now, this is going to be old tea. This is probably like a month old at this point, so it's kind of dated. But the value in looking at it is because of the penalty amount. And the other thing that I really wanted to look at is this is a very well-known organization, okay? And the violation here is data minimization. So if you've watched any of my reviews in the past, I've talked about the value of certain foundational privacy principles, one of which is data minimization, right? We're only going to collect data that is minimally required to conduct a specific processing activity. So I'm actually going to go to the link. It looks like the name of the organization here is General Motors. They've got a CCPA violation, which I presume is the sale of data and also data minimization. So if you're not familiar with privacy statute, there are statutes that require different obligations when you sell personal data. I will say that California has been one of the forerunners in terms of looking at ways to regulate how organizations sell or share data under specific definitions. We're going to go through the link and we're going to get the tea. So this is what was issued by the Attorney General. Consumers must be in the driver's seat. Partner secures 12.75 million from General Motors in a privacy settlement. Okay, so this is a result of, we'll scroll down, but essentially it's a result of, a violation to privacy legislation. And this is being issued by the California Attorney General. So we've got the California Attorney General here. They've issued this settlement with General Motors regarding its illegal sale of hundreds of thousands of California's location and driving data. So I've given definitions in the past of what constitutes personal data. I think one of the most important things for organizations to do is look at what the definition constitutes and do they meet the threshold in a specific geography, right? That's very, very important. As it stands in the United States, we have over 20 privacy state laws, right? California is not the only state with a privacy law. California is not the only state with a privacy law. There are other states with privacy laws, right? And they all have their own attorney generals and methods of issuing different types of enforcement actions against organizations that violate those laws. Right, this was issued May 8, 2026. So it's not piping hot tea, it's an oldie but a goodie. And I still think it's valuable because it talks about data minimization, which is a principle that every organization should be meeting. General Motors sold the data of California drivers without their knowledge or consent, right? If you take a look at my privacy in practice video number 2, I talk about consent and factors. If you are interested in cookie compliance, I've also done reviews of what the flow should look like on my channel, so take a look at that. But according to this report, General Motors sold the data of California drivers without their knowledge or consent, and despite numerous statements reassuring drivers that it would not do so. So this is why the representations on a website are so important. Anytime you draft a notice, it's incredibly important to make sure that the representations are what is actually happening in the organization. And if you watch my privacy in practice video number 1, you'll see that I talk about the types of personal data that I collect, right? I talk about the representations on my websites and the updates that need to be made in terms of tone, right? That's incredibly important. If you are making a representation on your privacy notice that says, we do not conduct this activity, and you do, you put yourself in jeopardy of an enforcement action. This trove of information includes precise and personal location data. Now, what's the importance of precise? Under certain US state privacy laws, precise geolocation data is a sensitive identifier. When we have sensitive identifiers, they require heightened safeguards by organizations, right? Because it's considered more sensitive, right? My name is Funmi Owolabi, and here's a picture of my face, okay? If you collect my sensitive personal data, that is considered more sensitive than just my name, right? My name's on the internet, and so is my email address, right? I've put that out into the public because it allows me to obtain business from clients that want data privacy services. But my precise geolocation data is not something I've put out on the internet, right? And if I am liaising with an organization and they tell me that they're not going to process this type of information, but they are processing it and they're not getting my consent, then that's problematic, right? This trove of information includes precise and personal location data that could identify the everyday habits and movements of Californians. Okay. Today's settlement requires General Motors to abandon these illegal practices and underscores the importance of data minimization in California's privacy law. Companies cannot just hold on to data and use it later for another purpose. I've talked about this a lot on my channel, right? You have to think about what is the minimally required amount of data that I need for this process. Look at my privacy in practice video number 1. If you take a look at my contact us form page, the only identifiers that I collect are name, email address, and I have a free flow form box that I've talked about in depth so that prospective customers can reach out to me if they have specific questions they want to talk about during our consultation call. I do not need any other additional information from prospective customers in order to understand that they want to be a customer of the firm. I don't need to collect their address. I don't need to know what their spouse's name is, and I don't need their social security number. So it's very important to only collect what is minimally required. The purpose of my contact form on my page is to know that you are interested in legal services. That is it. The only data I should be collecting in furtherance of that activity is data associated that is minimally required. There should not be any additional information, and there should not be any other requirements for my processing activity, which is understanding that a prospective customer wants to deal with the firm. It is patently illegal to secretly sell a consumer's personal data. To car companies who want to speed off with your data without your consent, these penalties should serve as a warning. No matter how big of a company you are, you will be held accountable in California, right? So this is very industry specific, right? We're looking at cars, but what is the value in looking at this T, this privacy T? The value of looking at this is this specific settlement is for a car company, but organizations that are not in the car industry are likely to see value in the language that has been used by the attorneys here. This is in relation to selling certain identifiers related to consumers, right? But there's a process that must be followed under statute in California, right? And I also want to add here that each state may have its own consumer state privacy legislation. It is the responsibility of the company to find out what its obligations are. Okay? Just because you don't know about the statute doesn't mean it doesn't apply to your organization. You have to understand what each state says and make sure that you comply based on what each state says. Just like it would be the same if there were certain measures that you had to apply when you're driving country to country, right? There are certain driving rules that are allowed in one country. What do those laws state? You have to follow them. Those countries don't care that you're a visitor to their country. You need to abide. And if you don't abide, there are going to be repercussions, okay? So I guess that's what is the essence of this provision here. Now, this is not piping hot tea because it didn't come out like immediately. I'm hoping through the series, What's the Tea in Privacy, we can keep looking at some enforcement actions or demands that are ongoing investigations, because those would be really valuable to see the different nuances. But I guess my final takeaway for this first episode in the series is that I think it's important to do a pressure check for a privacy program that your business has. Okay. And even though General Motors is a very large organization, the principles associated in the settlement action are not exclusive to large companies. You have to look at what the statute dictates when it comes to look at, do I meet the threshold? Do I meet the threshold is the first question for any organization. And this applies outside of California. This applies in other geographies with their own privacy legislation. I think one of the things that I do a lot on my channel is we look at a lot of federal privacy legislation. In the United States, privacy is fragmented based on sector, state, and on the federal level. So essentially, if you're starting an organization, you need to know what laws apply to you. Now, there's many laws with owning business, right? It's a responsibility. There are privacy laws that apply to you. And it's really important to look at the takeaways here. I say T, but essentially these are matters that affect organizations on a day-to-day basis. And it's really important to keep your privacy program compliant. So I really hope you enjoyed this review on what's the tea in privacy. I'm going to be having far more videos on what's the tea in privacy. We're going to look at old tea, we're going to look at goodies but oldies, and we're going to look at piping hot tea. So I hope you stick around and I hope you enjoyed this video, and I will see you in another What's the Tea in Privacy with Funmi Owolabi.